joining us today. My name is Nicole Agbayani, Director of Community Affairs for San Francisco Assessor Carmen Chu, and it is my pleasure to welcome you to the Assessor's Digital Family Wealth Forum on understanding how Prop 19 may impact your family. Before we get started, I'd like to go over a few housekeeping tips with you. First, we are committed to serve all populations, and so we are offering Spanish and Chinese interpretation today. If you prefer to listen in those languages, please go ahead and select the language channel you prefer at the bottom of your screen. Click on the Earth icon and select Cantonese or Spanish. Now I'll ask our Cantonese translator, Vivian, to please explain in language.
大家好，歡迎嚟到三藩市古籍觀朱家文辦公室舉辦嘅家庭理財講座。我哋今日嘅活動係會提供粵語嘅翻譯嘅。咁假如你係希望以粵語收聽今次嘅呢一個講座嘅話咧，請你喺呢一個影像嘅下方有一個好似地球咁嘅圖像。咁你點選咗呢個圖像之後咧，就可以喺列表入邊咧選擇你中意嘅語言。咁你就可以選擇 Chinese 中文嘅。咁你選擇咗之後咧，就會去到呢一個頻道入邊聽到呢個粵語嘅翻譯㗎啦。咁假如你想選翻去英文嘅話咧，亦都可以喺同一個圖像，好似地球嘅圖像咧，再點選一次，再選擇翻英語嘅。咁多謝各位，希望你哋可以喺今次嘅活動入邊得到一啲有用嘅資訊。多謝。
Thank you, Vivian. Now I'd like to ask our Spanish translator, Pablo, to please explain in language.
Buenas tardes a todos y gracias por acompañarnos hoy. Mi nombre es Nicola Bagayani y directora de Asuntos Comunitarios de la tasadora Carmen Chu de San Francisco. Es un placer para mí darles la bienvenida al foro de la riqueza familiar digital del tasador sobre cómo comprender cómo la proposición 19 puede afectar a su familia. Antes de comenzar, me gustaría repasar algunos consejos de limpieza con ustedes. Primero, estamos comprometidos a servir a todos las poblaciones, por lo que hoy ofrecemos interpretación en español y chino. Si prefiere escuchar en esos idiomas, continúe y seleccione el canal de idioma que prefiere en la parte inferior de la pantalla. Haga clic en el icono de la tierra y seleccione cantonés o español.
Thank you, Pablo. A couple of additional housekeeping items. Today's webinar is being recorded and being shared on YouTube Live. It will be shared on Assessor Chu's other social media platforms and the Assessor's website at a later time. We will also email the recording to all registered attendees after the event. Please consider subscribing to the YouTube channel for similar programming in the future. For those of you joining us on Zoom, there is a question and answer function that is located at the bottom of your screen. At any point, if you have questions, please type them in and we will try to address them during the webinar. If we run out of time afterwards, we will follow up with you. We ask that you add your questions to the Q&A box and not the chat box to ensure that we can follow up with you afterwards. If you are joining us on YouTube Live or have questions following the event, you may email them to assessor@sfgov.org. Next, a reminder, the information provided is intended to provide general and summary information about Proposition 19. It is not intended to be a legal interpretation or official guidance or relied upon for any purpose, but is instead a presentation of summary information. Proposition 19 is a constitutional amendment, so additional legislation, regulations, and statewide guidance are expected to clarify its implementation. If there is a conflict between the information provided here and the proposition or any legal authorities implementing or interpreting the proposition, the text of the proposition and other implementing or interpretive authorities will prevail. We encourage you to consult an attorney for advice on your specific situation. All right, with that, it is my pleasure to introduce our moderator for today's webinar, Deonjay Bruchter. Deonjay is the Executive Director of Young Community Developers, a nonprofit community-based organization providing education, training, employment placement, and housing services to San Francisco's residents in the Bayview and Hunters Point. His organization has also become a hub for essential services to support the community during COVID. Deonjay also serves as a San Francisco Police Commissioner. Please welcome Deonjay Bruchter.
Thank you so much, Nicole. And it's an absolute honor and pleasure to be here with you all this afternoon. As Nicole stated, my name is DJ Brookner, and I'm the Executive Director here at Young Community Developers. And what I wanted to do today to ground this conversation is just really ground us with where we are right now. Here at Young Community Developers, we're saying that 2020 has been a year of challenge and opportunity. The COVID-19 pandemic, racial inequities, and California fires have served as backdrop for the work here at Young Community Developers during 2020. During these unprecedented times, we remain committed to engaging and empowering the residents of Bayview Hunters Point and sharing their stories of resilience to a wide audience. The challenges of this pandemic year have shed light upon the issues of discrimination, racism, and poverty within our country. Since 1973, YCD has served the most underrepresented and under-resourced community residents within San Francisco. At our core, we provide the career and professional services, resources, and support needed to achieve economic mobility. And we will continue to expand our services, which include job readiness training, youth development, education, reentry support, and housing advocacy. These services advance our mission as we aim to break the cycle of generational poverty. And I think as we have this discussion, I'm so happy that our assessor wants to speak to us all about understanding how California Prop 19 can impact you and your families. We're just going to go ahead and dive right in. Now I'd like to take the time to introduce the three speakers that you guys will be hearing from today. Our first speaker is San Francisco elected Assessor Carmen Chu. Assessor Chu has served as our city's assessor since 2013. She founded the Family Wealth Forum Educational Services back in 2017, which now serves over 1,500 families. Assessor Chu serves as the Vice President of the California Assessors Association. And since the COVID-19 pandemic crisis began, she has also served as the co-chair of the San Francisco Economic Recovery Task Force, which I was also a part of. Thank you for all your work, Assessor. Next, we'll hear from Mr. Larry Pond of Pond and Associates. Larry is a certified financial planner, certified public accountant, personal financial specialist, and accredited estate planner. And he has been practicing here in the Bay Area since 1986. Larry, looking forward to hearing from you. And finally, we will hear from Carrie Reardon Sykes. She is an estate attorney with Reardon Sykes McFadden, and Carrie has been a certified legal specialist in estate planning, trust and probate law with the California Board of Legal Specialization since 1997. And she's continuing in the family business of her father and grandfather. And Carrie has assisted hundreds of Bay Area families with their probate and trust matters. Needless to say, we have an amazing lineup planned for you all today. And we're going to hear about vital information for you and your families to think about in regards to Prop 19. So let's go ahead and get things started off by welcoming my friend and colleague, Assessor Carmen Chu.
Thank you so much, DJ, and to the co-panelists, thank you for joining as well. And to all of the attendees who've joined us today, I want to welcome you to this seminar. I think when we think back about all of the different challenges that we've had in 2020, it's been a very tough year. And so I think many of us are excited to turn the leaf and to welcome a new year with new possibilities and hope. I hope that you all had a wonderful holiday season and of course a safe one as well. Speaking a little bit about this seminar today, I can't tell you how excited I am for this event. We had not that much time to pull all of this information together, but we saw such a huge need in the community from the hundreds of emails, telephone calls, and reach outs to our office. We heard from constituents, families, individuals all across our city with some real concerns and worries about what this proposition would mean, in particular in light of COVID-19 and some of the additional health consequences that we're all facing right now. We have, so you know, about 2,300 people who registered for this seminar in a short week and a half, 2-week time period that we put the information out that we were holding this event. Not only that, but we received over 900, roughly 900 questions that were pre-submitted to us as well. So you can just see the level of desire and the hunger for information to make sure that you have the best data, the best information possible to make the best decisions that you can for yourself and for your families. When we first put together the Family Wealth Forum, it really came about from all of our community meetings. We went all across the city to neighborhood events and groups all over the place. And what we heard from people were just a simple question. We heard the question of, I have my family home. It is the most important asset that I have and also the most valuable. How do I pass this on and make sure that my kids have the ability to use this property, to be able to live here and stay in San Francisco? That question brought about a whole lot of other questions that we had about the types of resources that were available to many members of our community, in particular monolingual community members, as well as low-income communities, and why we sometimes don't have enough information or access to resources in many of our communities of color. And so we really started to put together the Family Wealth Forum in an effort to say, let's try to level that. Let's try to make sure we get information out to people so that, again, they can make the best decisions for themselves, but to their families as well. And so what was born was the Family Wealth Forum. And now, since the time that we started it, we've helped over 1,500 families get access to information and sometimes direct counseling from many of our experts, some of which you're hearing from today. And so I'm going to get started and jump right in. But again, I'm super excited about this event. I hope that you learned something valuable from this, not only about Prop 19, but about how property taxes work and some of the other considerations that you should have for your family when thinking about how to plan for the future. And just remember, sometimes this information might sound daunting. It might sound like I have so much that I don't know, but really the path to making sure that you understand your finances and where things go, it just starts with a simple step. The simple step of you joining us today to learn more about what's happening and the law, it sets you on the right path going forward. So again, I'm super excited for this event and glad that you've all joined us. And so with that, we're going to start turning it over to our presentation. All right. So as you know, my name is Carmen Chu. I serve as San Francisco's elected assessor. And one of the things that we do have to make sure that we put forward is administering the property tax laws for the state of California. As many of you may know, Proposition 19 was put on the ballot this November, and it won by a relatively narrow margin, roughly about 400,000 votes separated from winning in this election. Roughly about $50 million was put into the campaign to get this ballot measure to pass. Almost no money was actually spent to oppose this ballot measure. Originally, this started off as an initiative measure that qualified for the ballot by the California Association of Realtors. Over time, what ended up happening was that the state legislature, through Assembly Constitutional Amendment number 11, put forward this ballot measure. And so now what you see before you is that we actually have a ballot measure that was on the November ballot. It passed again at that time. The Secretary of State certified those election results in early December. And that's when we knew that for sure, definitively, this measure had passed after all the votes were counted. And we know that now this legislation is going into effect. That being said, it's been a very quick turnaround time for when this legislation would go into effect. You'll see on the slide that there's actually two parts to when this will go into effect. The first part is in February. So the first part that we're going to be speaking about today will be in effect February 16th. And then the second one will be in effect April 1st. So as I mentioned before, there are multiple pieces to this piece of legislation. It was a measure that was put forward, but often what will happen is that you're going to see the state legislature as well as the State Board of Equalization pass on additional laws or regulations to help clarify many pieces of the law that where it was not clear to begin with, or where there was missing pieces in terms of how we would put it into effect. So just know that even though this law is going into effect relatively soon, the legislature and the state board still have a fair amount of work to do to advise assessors across the state on how it is that we have to implement this particular piece of law. At this moment, I actually should also mention that we're joined today by Malia Cohen, who is also a member, our elected State Board of Equalization member. I know that she's joined us today and she's been working very closely in partnership with all of us to make sure that this gets implemented as smoothly as possible. And so, again, as I mentioned, the piece that we'll be speaking to about today really deals with the transfers between parents and children. And so just to give a background for folks who may not know, under Proposition 19, many different things were part of it. One part of the change was that it extended benefits to seniors, disabled individuals, and people who were impacted by wildfires to be able to have a replacement home and carry on their Prop 13 values. That's an expansion of a benefit. There was also a restriction in benefit when it comes to the transfer of properties between parents and children, and by extension also from grandparents to grandchildren. And so just something to know that there are two parts of this. We're going to be just covering the transfers between family members, in particular parent to child, grandparent to child transfers. Next slide. So in order to begin, especially because we have so many people who've joined us today, we want to make sure that people have an understanding of how property taxes work to begin with. So for folks who already know this, please bear with us for just a moment as we make sure that everyone comes up to speed so that you understand what the differences really do mean for you. And so one of the questions that we first get, of course, are how are property taxes calculated in the state of California? And so, as you know, in the state of California, we have 58 different counties. Every single county has to follow the same exact property tax law that exists for the state of California. And so local jurisdictions can't change these regulations. It's actually regulated all by the state government, as well as the state constitution and state laws. One of the things to know is that your property taxes basically have what is called an assessed value. So it's your taxable value for your home. And generally we'll multiply that by the tax rate. The ad valorem tax rate by the state of California is 1%. Sometimes your tax rate might be a little bit higher, and that's simply because locally in your jurisdiction, you might have passed bonds or other types of tax measures that slightly bump up that level. But for the most part, you want to start off with assuming that your tax rate will be roughly 1%. So if I have a $1 million home, if I multiply that $1 million assessed value to 1% with 1%, you're going to see a tax bill annually of $10,000. And so that's typically how your tax bill gets calculated every year. Next slide. And so how do we set what your taxable or assessed value is? Typically what happens is that when you purchase your home, the assessor, there's one elected assessor in every single county in the state of California, we set the assessed value. So we basically say, what is the fair market value of this particular home when you acquired it? And so that becomes your assessed value. Over time, we're going to use that assessed value to basically calculate what your taxes are, your obligations are. So I'm going to walk through sort of an example for you so you understand how Prop 13 and how property taxes work in California. So let's just say, for example, you purchased your home back in 1990. And when you bought that home, it was worth $100,000 in terms of the market value. Basically, in an arm's length transaction out in the marketplace with other people who were competing to buy this property at the same time, you were able to win this bid and buy this house at $100,000. We would consider that to be the fair market value of the house, and we would set that as the base value, or basically your assessed value for your home. So for tax purposes, that $100,000 is used, multiplied by 1% to get to your $1,000 tax bill in this situation. Under Proposition 13, what you see is that there's also a restriction. So what we say under the state law is that, and this was passed in 1978, is that we're going to make sure that we have your assessed value. It starts off as your base, and every year thereafter, we can't increase your assessed value or your taxable value by more than 2% every single year. And so you can imagine over time what that looks like. Over time, let's just say you start off with a house that was worth $100,000 back in 1990. If you progressed and you multiplied every year, $100,000 times another 2%, and then the next year another 2% and another 2%. Over a 30-year period, your $100,000 taxable value becomes roughly about $185,000 rounded up in terms of a taxable value. So we typically will be taxing you at this lower assessed value. However, during that same 30-year period of time, it's quite possible that the value of your home has actually gone up by much, much more, because we've seen that even though the state has said you can't increase your taxable value by more than 2%, we've seen that home prices, for example, in California have gone up by much, much more. So you see in this graphic, you can see where the blue line shows what your taxable value is, again, restricted by Prop 13, doesn't grow by more than 2% every year. But at the same period of time, it could have grown to a value in the fair market sense to 1.5. So let's just say I was out in the marketplace, I wanted to sell my home. Maybe I would be able to sell my home at this moment in time in 2020 for $1.5 million, even though I'm being taxed at a lower rate of $185,000 roughly. And so over time, the longer people have owned their property, essentially they've had a larger tax benefit, being able to preserve sort of a lower taxable value over time. Now, many people have asked the question about, well, in what instances would I see an increase in my assessed value, my taxable value? There really are primarily two main drivers to that. The first is that there's construction that happens. So I own my property and all of a sudden I want to add an additional room. I want to add an additional restroom. In that situation, that new construction would be taxable at market value as of the time that you constructed it, basically. Now, people say, well, what happens to the rest of my house? Well, let's just say you add one room. We're just going to add the market value for that particular addition, that room, but the rest of the Prop 13 value associated with the remainder of the house remains the same, so long as you didn't change anything associated with that rest of the house. The second instance in which we change properties' values to market would be when there is a change in ownership. So when I sell to a new party, a new person, or a new family who may want to buy my home, that's considered a change in ownership, and that would trigger a reassessment where we would reset your taxable value to the market value. So again, we're going to see this particular example, and if we can advance the slide through. What you see here is that I might have owned, or the previous owners bought their home in 1990. Over a 30-year period, it's only increased by 2% every year in terms of the taxable value. So they're being taxed at $185,000 in terms of taxation. But if a new property owner decides to buy it and they sell this property to this new family, what would happen is that we would then reset the taxable value or the assessed value to the market value in 2020. In this case, $1.5 million for that new particular homeowner who now owns the property beginning in 2020. It has a big difference in terms of taxation. So just take a look on the left-hand side, you see what the calculation for tax would be for someone who owned it since 1990. Their taxable value was $185,000. So the tax they were paying annually was about $1,850. For the new family, the new people who purchased the home in 2020, their assessed value, recall, was reset to the market value of the home at $1.5 million. And so their taxable amount now is $1.5 million times 1%, which is roughly $15,000. So $15,000 in taxes versus annually $1,800 is a pretty big difference.
No, thank you so much for that, Assessor Chu, and really that explanation that you're giving on Prop 13, I think is extremely, extremely helpful. So as we continue to lean into the conversation, can you explain how the law currently treats changes in ownership between parents and their children?
Absolutely. So that brings us to our next question, and then we're just going to advance the slide to the 3 bullet points, if I can ask. And so right now, if you think about it, if I decide that I'm going to transfer my property over to my children, essentially that's a technical change in ownership. I'm no longer the owner. My children are now the owners of that property. And so recall in the previous slide, that's in a situation where it would actually trigger typically a reassessment to market value. However, a legislation was passed in 1986 called Proposition 58, which basically said that if you are seeing a transfer that went from the parent to the child or from the child to a parent in either direction, you could be excluded from a reassessment to market value. And here are generally the rules. And so it has to be in terms of what it is that you can pass on. So aside from making sure that the relationship is clearly kind of a parent and child transfer, typically what they allow to transfer without a reassessment to market value is a few things. The primary residence that you live in, regardless of value. And so if I own my home that I live in right now, it's worth $1 million, I could pass that on to my child, but pass on my lower Prop 13 value to them without restriction. So if my property was $1 million or if it was a $20 million property, so long as it's my primary residence being passed on to my child, it wouldn't have to be reassessed to its market value. The second piece is that currently under the law, even if I pass on my primary residence to my child, they don't necessarily have to live there. They could decide to live there if they wanted to. They could end up moving out and renting it out if they wanted to. There is no restriction on how you utilize that property going forward for the child who inherited it. And then finally, on top of your primary residence, in terms of what you can transfer over in terms of a low tax value, you're also able to transfer other property over to your children up to an assessed value of $1 million. So for example, if I own the home that I live in, I pass that on to my children, no restriction on the value, but I might have maybe a rental property or maybe a commercial property that I could also potentially pass on to my children and preserve that lower tax basis for them going forward. And there is a limit in terms of all other properties, not your primary residence, and that limit is $1 million of the assessed value of the property, not the market value, but the assessed taxable value of the property. The way this works is that if there is $1 million cap, each parent can pass on 1 million. So if you have two parents, for example, you can pass on up to $2 million of value, assessed value from yourself to your children in this case. And again, remember that in this situation, this is a parent to child or child to parent, it's two directional. So in this situation, you take a look at the same example we showed you earlier. If I own my property since 1990, bought it originally at 100,000, over time with Prop 13, I'm being taxed at a level of $185,000. My children, it would be considered a change in ownership if it transferred to them. Normally, you might have to reset it to that $1.5 million example in terms of a market value. However, because it is qualifies for a parent-to-child exclusion, my child actually benefits from being able to pay continuing at the lower taxable rate of $185,000.
Oh, thank you so much for that. And I hope folks are really hearing and understanding, this is how the law currently treats, the interactions between parents and children. And thank you for letting us know that they're also transactional in both directions as well too. But as we come into 2021, Assessor Chu, can you now describe how the law will change starting in February for families under Proposition 19?
Yeah, and I think, DJ, this is really important because we have many people who have maybe purchased their home and they want to pass on their property, their home, the home that their kids and themselves have been living in, to the next generation. And sometimes when you see sort of a reassessment happen, it's not possible for the family member to continue paying that property tax at a higher level. So we've seen that a number of times where it's really been a financial problem in terms of a reassessment if this law didn't exist for the transfer from a parent to their children. And so we're going to talk a little bit about what Prop 19 does. And so, as I mentioned, Prop 19 was passed in November. It was certified in December, and this piece of it is going to go into effect in mid-February. So it's a very fast turnaround time. There's a lot we do know about the law because it was written in the language of what was passed on this ballot. However, there's also a lot of pieces that we don't have the answers to yet. That's going to require the state, again, to pass additional laws to clarify, or for the state board to be able to clarify more as well. So just know that there's some pieces that we can answer about your questions and other pieces that still need to be clarified. So if I can ask Nicole to advance through to the end of the slide so we can just go through these. So as I mentioned before, these are the same three items that we talked about earlier. So again, in the past, you can transfer your principal residence with regardless of the value. There was no limit on how you use the property. And then on top of that, you can pass on an additional $1 million per parent in assessed value to your children. Under the new law, there are pretty significant changes. Number one, you can still transfer your principal residence to your child, and it's two directional still. However, there is a new limit to it. So in the past, where it didn't matter if your property was worth $1 million or $20 million or $15 million or $2 million, now there's actually an upper limit that actually has an equation. We're going to go through the equation a little bit later, but it's really just to say that conceptually, there is actually an upper limit to how much taxable value you can pass on to your kids now. That's different from before. The second piece is that in the past, there was no restriction on how you use the property. Now there is. In order for you to benefit from keeping that lower tax basis, the person who inherited it, so whether it's the parent who got it or the child, you actually have to now live there as your primary residence. And that's a requirement now under the law. So if you received it, but you don't live there as your primary residence, you don't get this tax benefit. And then the last piece of it is that any other property other than your primary residence no longer qualifies for this program. So that means if you had a rental property, or whether it was a residential rental or a commercial rental property, none of that would be eligible to receive or to pass on that lower tax basis to your children, or vice versa to your parents. And so just walking through what a scenario can look like and what the calculations look like. And if I can ask Nicole to advance through to the slide. Let's just give you an example where at the time of you transferring a property, the assessed value, and this is under Proposition 19. So not under the existing law, but this is once Proposition 19 goes into effect, February 16. This is how this would look. Let's just say that at the time that you transfer the property, the assessed value of your property is worth, this is the principal residence, is worth $1.5 million, but the market value is worth $1.8 million. Let's just say that the other piece is that the child moves into the property as a principal residence, and so they meet that condition. This is how we would basically take a look at that calculation. We would take the assessed value and add $1 million. This is how the equation works. So in this case, it's the 1.5 million plus $1 million and equals 2.5 million. We determine whether the market value is higher than this number or not. And in this case, 1.8 million is higher than this number, right? Or is not higher, it's not higher than the added value, so 2.5. And so in this case, because your $1.8 million market value is not higher than 2.5, basically your assessed value plus $1 million, then essentially you get to keep the assessed value of your existing property. So basically, in this case, you would see that it is going to stay at an assessed value of 1.5 million. All right. So let's give you another example, an example where in this case, again, it's the same house. Its assessed value is 1.5 million, but the market value is $3 million. So let's just say again that the child ends up inheriting it and also has it as its primary residence. So it meets that criteria again. So you add that $1 million to the assessed value. So 1.5 million plus $1 million gets you 2.5. We do the same comparison again. So we say, is the market value higher than the 2.5 million? In this case, because the market value is 3 million, it is higher. And so we calculate the difference, $3 million minus this 2.5, and you get $500,000. What we would now do is that we would take your existing assessed value, which is the 1.5, and add this difference of $500,000 to get to a level of $2 million. So essentially your new taxable value is $2 million. Notice that it's not as low as your old assessed value at 1.5, but it's also not as high as the market value of 3 million. So in this case, you do get a benefit, but it's not a complete benefit. In the next scenario, we're going to say that the child doesn't move into the property. So they inherit the property, but it is not their primary residence. In this case, you would not qualify for this property savings, and you would be now taxed at the $3 million level. And then finally, the last example, you have a rental property worth 1.5 million. So not a primary residence, but a rental property. Its market value is 3 million. Do you get a tax benefit after Prop 19 passes or goes into effect? You do not, because any other property aside from a primary residence is not eligible for this program. All right. So this is just a slide that kind of goes through again what that calculation looks like. We don't need to go through this again since we went through those few examples.
Thank you so much for that, Assessor Chu. I think being able to hear it that way and break it down makes it more palatable, right? When we're able to see true scenarios and kind of go through the actual breakdown to see what the assessment itself looks like. So Thank you so much for that. And so I think it's understandable, though, why many families may be concerned about the changes to the law, that we're seeing and hearing about. So for families who are considering taking advantage of the existing law before February 16th, what are some of the important things for them to consider before taking any action?
Yeah, and this is the $1 million question or $50 million question, whatever you want to say it's worth. But I think unfortunately we can't tell you what the answer is because it is so personal to every single family. So the two speakers who are going to follow me will also give you a few other things that you might want to consider before making your decision. But a few things I want to bring out so that you can start thinking about this. One, you want to be thinking about the financial or tax implications of your decision to transfer now to take advantage of the existing law, or if you just want to leave it and you're okay with kind of living within the Prop 19 framework. Because what I've shared with you earlier is really just the tax impact associated with your annual property tax bills. There are other taxation elements that sometimes come into play if you decide to pass on your property now or later. So for example, some of the things that Larry's going to speak to you about is what happens potentially with gift taxes, federal gift taxes, or estate taxes, or inheritance taxes, or capital gains taxes. Remember what I spoke with you about earlier was just simply one tax out of potentially many. We were just speaking about the impact of Prop 19 on annual property taxes, depending on when it is that you transfer your property. There are other taxes you're going to want to consider, again, that Larry's going to cover in just a little bit. The second piece is that you also want to make sure you think about property rights. Ultimately, if you decide to transfer now, or you just want to transfer later, or you want to transfer upon you passing away, it has implications because if you pass on your property, you are no longer the owner. And so I've heard many families who have instances where they may have said, I really want to try to pass on tax savings for my children. They pass it on, but the children had a different idea of what to do with the property. Maybe they ended up mortgaging that property and taking debt out on that property, or maybe they decided to sell the property, and the parent who originally planned to live there until they couldn't any longer, no longer had control over the ability to use that property. So it's really important to think about this piece because remember, at the end of the day, it's for many people, your house is your security. It's the place that you plan to live in, to grow old in. And if you no longer own it, you simply no longer have any legal rights to it. So that is something that's incredibly important to think about and consider as you think about what to do next. The third thing I would recommend is you definitely want to seek professional help and advice because our office and others on this call cannot provide legal advice to you at this moment because everybody's situation is so unique that you're going to want to get legal advice that specifically pertains to you. We have different family members, we have different conditions, we're in different health outcomes, we have different jobs, we have different kinds of assets. And because of that, it's really hard to tell you what is the right answer. You have to consider all of these things before you make a decision. And finally, the one thing I will say is that if you do decide that you want to make a change and you do decide you want to transfer the property before that February deadline, don't wait till the last minute. We're going to be likely seeing a lot of people who are going to be reaching out to try to get their documents recorded with us. In addition to that, you're going to want to take the time to have conversations with your family members, to seek legal advice, and to do all of the planning that's necessary to do it right. So make sure that today you hear the information, learn as much as you can from today's session, but really don't delay. Really try to get your things in order as soon as you can so that you have the time to think about it and to do it correctly. And so with that, I'll turn it back over to you and the other panelists.
Thank you so much, Assessor Chu. And two takeaways that I really heard is don't wait and do it right. And that's what today's conversation is all about. And that's a great segue to bringing up Mr. Larry Pond. As I mentioned early on, Larry Pond is a CPA with decades of experience who's going to help us kind of unpack some of the tax consequences to consider as a family before transferring of property. So Larry, I'd like to ask you, if you're working with someone and they're considering transferring their property to their children now, what tax consequences do folks need to be aware of besides the property taxes themselves?
Hi, DJ, and thank you, Carmen. That was a very, very good explanation of what happens with property taxes. Well, in this country, besides property taxes, we have many other kinds of taxes to be considering. We have to consider the impact of income taxes, and that's at the federal level and the California level. We also have the gift tax consequences and the estate tax consequences. So let's talk about what this means here. Let's go to the next slide. So I think it'll depend upon what the children's plans are with the property. So For example, for income tax purposes, if the parents hold on to the property until they pass away and the children inherit the property, you get what's called a step up in basis. So what that means is the property gets stepped up to the value at the date of death, and which means if they decide to sell it, they will not have any capital gains tax. So if the children are likely to sell the property, they're not going to keep the house or whatever, it might make sense not to transfer the property now, but wait until the parents die so they can get the step up in basis. However, what if the children want to keep the property? As Carmen was saying, to keep the parents' assessed value, they got to use that as their principal residence, which means claiming the homeowner's exemption on that property. Or what if they want to convert it to a rental property? So I think you've heard of this. You can go to Google and type in Lebowski loophole. Remember the great Lebowski? Well, Jeff Bridges and his siblings inherited their Malibu house from his parents, and they were renting it out for over almost $16,000 a month, and the property tax was about almost $7,000 a month. So he took advantage of what's now called the Lebowski loophole. And that's what this law was written, was to eliminate that loophole. So if you convert to rental property, the property tax assessment will be increased to what the market value of the property at the time they inherit it. And also, so we need to evaluate, do we want to maintain a step up in basis or preserve the property tax base? So that's something that needs to be considered before making this decision. Let's go to the next slide. So let's go over this example here. So let's say the parent's primary residence and the child's going to also live in there as a primary residence, and the base is currently at $500,000. And to make the math easy, let's assume the cost basis of this house is also $500,000. Well, it's currently worth $1.3 million. So if we take 1.3 million minus $500,000, the difference is $800,000. And so since the $800,000 is less than $1 million, there's no reassessment upon transfer of this property, like the example that Carmen showed earlier. So the tax base for property tax purposes will remain at $500,000. That's great. You keep the same property tax base. But what if the child decides to sell the house and they just turn around and sell it? So we sell it for 1.3 million minus the $500,000 cost basis. This child will have an $800,000 capital gain. This child will have to pay taxes on $800,000. Well, let's say the child sells this house 2 years later, because you have to use the home as a principal residence for at least 2 years to get the $250,000 gain exclusion. If the child's married, then that's $500,000. So in this example here, 1.3 million minus the 500,000 minus 250, instead of an $800,000 capital gain, you have a $550,000 capital gain. Let's go to the next slide. So let's say the parent does not transfer the property to the child. The parent holds on to it until they pass away. So the child inherits the property. Child moves into it. But if the child decides to sell the property, there's a step up in basis. Let's say it's $1.3 million at the time of death, and they sell it for $1.3 million. So 1.3 minus 1.3 million is zero capital gains. So that does make it a big deal. Now, if the child does not use the home as a principal residence, the property tax base will be reassessed to market value, which in this case will be $1.3 million. Let's go to the next slide. The other tax we have is called the gift tax. So this is known as a transfer tax. We have a gift tax and an estate tax. So what's the difference? It's a gift tax if the donor, whoever's transferring the property, is still alive. If the donor is deceased and it's being received via inheritance, then that's when the estate tax kicks in. So if the parent wants to transfer their property to their children now, they got to consider the gift tax. Now there's a current annual exemption of $15,000 per donee. So you can give anybody up to $15,000 without having to report any gifts. So it's a $15,000 per donee. If there's two spouses, that's 15 times 2, that's $30,000. If the child is married, that's another $30,000. So the parents can transfer up to $60,000 to their adult married children. Now for 2021, there's a lifetime exemption, also known as a basic exclusion from estate tax of $11,700,000. So for a married couple, that's $23,400,000, which means you don't pay any gift tax or any estate tax as long as you transfer less than $11,700,000. Now, when you file a gift tax return, the form to file is Form 709. So you can go to the IRS website, take a look at Form 709, and look at the instructions. Next slide, please. So let's carry on the example we talked about earlier. The parent decides to gift the child a home. So on the Form 709, they're going to report the $1,300,000 gift minus the $15,000 exclusion. So the taxable gift is $1,285,000. However, that $1,285,000 is credited against the basic exclusion of $11,700,000. So that means we used $1,285,000 of the basic exclusion. Then you get $10,415,000 going forward. And in this case, the gift tax will be zero. Okay, next slide. Now, the estate tax occurs if the children inherit the property, and the basic exclusion is $11,700,000. So if the estate's below that amount, there is no estate tax. But if your estate is more than that, the current estate tax rate is at 40%. Now, the way the law is written, this law will change on January 1st of 2026. The exclusion amount will be reduced by half. But depending on what happens with the new administration, this might happen sooner. So the form to file for estate tax is Form 706. And generally, most Americans aren't going to be paying the estate tax. However, on the death of the first spouse, we might want to file the Form 706 to take advantage of what's called portability. It's to take advantage of the deceased spouse's unused exemption. So then the surviving spouse will have a larger exclusion carried forward besides his or her own exclusion amount. Next slide. So we need to evaluate the property tax savings versus the capital gains taxes. We need to do an analysis before we jump into things. Got to review your estate plan. You got to update your estate plan. Many people have out-of-date estate plans, but not just taxes. You also got to consider the non-tax consequences of transferring property to children or adding children to title property. There are other consequences. Can they handle the responsibility? We've heard and seen many of these sad stories. Had a client where the father gave a daughter a house and she managed to lose it, or all kinds of crazy things happen. What if the child is irresponsible? They have liens or they owe taxes, and it can cause a lot of headaches. So you got to be careful before you start adding children to title or transferring property to them. So it's very important to work with a knowledgeable and experienced advisor to review all the variables, not just property taxes, income taxes, gift tax, or estate taxes, but all the various variables. So next slide. So the considerations we think about is, what if I have a property in a low tax base but high market value? Do we want to retain that low tax base? Are we going to keep the property for a long time or a short time? I think the ones we're going to see the most are vacation homes, because that can be a property that they want to keep in the family for many generations. So those might be the type of properties that will probably be transferring versus the home. Second homes, vacation homes, those types of things. Got to review with the kids or the grandkids what they want to do with the property. Are they going to keep it? Are they going to move into it or rent it out? And with rental property, also what's mixed use property? Like what if you rent out downstairs but you live upstairs, and those sorts of things. And how's this estate going to be allocated among family members? One wants to live in there, one does not want to live there. Do they want to live together again to just save taxes? Does that make sense? So we have to see what makes the most sense for the different family members. Next slide. All right.
Thank you so much for that, Larry. That was a lot of wealthy, rich information. So we heard it's not about just income taxes or gift taxes or state taxes. We talked about property tax savings. There were some scenarios and examples in there. And one of the biggest takeaways that I took, Larry, by that conversation is just making sure within our families that we are communicating, and we're receiving the proper education that we need when it comes to taxes. So thank you so much for that. So now we're going to transition a bit to our next speaker, Ms. Carrie Reardon Sykes. Carrie, as you've seen, we've received many questions from attendees about how Proposition 19 affects properties held in trusts. So Carrie is going to break that down for us a bit. So Carrie, let's start with our first question. Does Proposition 19 affect real property held in a revocable trust?
Thank you, DJ. And thank you to Larry and to Carmen, because I really think Carmen's analysis of the property tax and Larry's analysis of all of the other taxes, really, that is the layered analysis that a parent and the whole family and the children receiving the property have to go through. So to answer the question, does Prop 19 affect real property held in a trust? A lot of my clients have asked me that question. They said, I have a trust. Do I need anything else? And the simple answer is that a revocable trust does not protect a real property transfer from the legal effects of Prop 19. And for those of you who are unfamiliar with a revocable trust, they are grantor trusts. They are generally established as a will substitute so that the estate does not have to go through probate. It is a revocable trust is not an entity. For example, with a grantor trust, with a revocable grantor trust, the grantor uses his or her social security number. A revocable trust holds title to real property, but it really acts as a see-through to the grantor, and the grantor is the person who establishes the trust. So in sum, all of the effects of Prop 19 apply to real property held in a revocable trust. Now, alternatively, there is currently discussion amongst estate planners about an irrevocable trust's effect on real property under Prop 19. And an irrevocable trust is a trust that cannot be changed by the grantor. It's the grantor's way of giving away all of their current ownership in their real property, and albeit that giving away control of the real property. And I think Larry and Carmen both brought up examples that when grantors do that, sometimes it doesn't go the way they want it to go. Some estate planners are establishing a revocable trust for children prior to 2/15/2021, where the parent does not retain a beneficial interest in the trust. And that is so they can obtain the Prop 58 parent to child exclusion. However, the irrevocable trust must include a provision whereby the parent can, for example, change the beneficiary, not to themselves, but to somebody else, so that the property can arguably receive a step up in cost basis upon the parent's death under Internal Revenue Code Section 2036. And without getting into the minutiae of that, some estate planners, including myself, are uncertain whether this type of irrevocable trust will accomplish the goal under 2036. However, if you are interested in learning more about this, you should speak to an estate planner who does this kind of work.
Thank you for that, Carrie. And along the same lines, this next question is quite similar. So what about folks that have a revocable transfer on death deeds? And how does Proposition 19 affect them?
Right. In California, about 10 years ago, we had the ability to record transfer on death deeds. And in this deed, you can designate a beneficiary to a piece of real property upon the owner's death. Very similar to a life insurance policy beneficiary designation or a retirement account beneficiary designation. However, because the transfer does not occur until after the owner passes, and if the death occurs after February 15th, 2021, then these deeds, like the revocable trust, does not avoid the effects of a Prop 19 transfer. And as a note, actually the transfer on death deeds the use of them were supposed to expire on January 1, 2021, and they have been extended to January 1, 2022, but just keep that in mind if that's something that somebody's going to use.
Oh, thank you for that. And I think finally, there's questions that have been coming in regards to younger families here in San Francisco.
Yes.
Many have reached out and they ask if they can transfer property to a minor child.
Yes.
and what that can look like.
Yeah, a lot of clients have asked me that. There's this sense of anxiousness of, should I transfer something to a minor child right now? And under California law, a minor may own real property, and that was under a case law about 100 years ago. And a minor is someone under 18 years of age. However, under statutory law, a minor may not convey or make contracts relating to real property. So therefore, a minor cannot sell, borrow, lease, rent, or purchase property held directly in his or her own name. So because that is a problem, a child would need a guardian ad litem appointed for them by the court. A guardian ad litem is a legal guardian that can protect their interests. So that's one way. The second way is, and this is generally the way that most people choose, if you're going to want the minor to benefit from real property or own it at a certain period of time, then you'd set up a trust for them. And that would require a trustee holding the property until the beneficiary reached the age in the trust so they could outright own title. And that's actually a benefit to a trust because you can control the age for your child, as opposed to having a guardian ad litem where they would get the title at 18. But now another alternative to creating a trust for a minor is under the California Uniform Transfers to Minors Act, otherwise known as CUTMA. And under CUTMA, it's a statutory mechanism for transferring real property to an adult custodian for the benefit of the minor. In other words, CUTMA is the mechanism whereby gifts, including money, real estate, and inheritances, can be given to a minor who is a resident of California at the time of the transfer. Now, CUTMA also applies if at the time of the transfer or the minor or the custodian is a resident of this state or the custodial property is in this state. But what the deed requires is that there be certain language in there that says an interest in real property is recorded in the name of whomever as custodian for the name of the minor under the California Uniform Transfers to Minor Act. So there are several ways to transfer property to minors. But just as Larry said, there are so many legal consequences to doing so that I would definitely recommend talking to a legal or tax professional before you engage in doing something like that.
Thank you so much, Carrie. Just being able to, shed light on how Proposition 19, works with various types of trusts and for families considering transferring property, right now to minors. It's very educational and very informational. So I want to thank you for that. And we are almost ready to jump into the Q&A portion of the program. We have given you a lot of information, and we see that there are a plethora of questions that just keep on rolling in and keep them coming. But before we transition to questions and answers, we'd like to wrap up the presentation by inviting Larry Pond and Assessor Chu just to present some final questions and additional resources, which will be really useful for families that want to act before the effective date. We'll go ahead and start off with Larry.
Hi, DJ. So these questions here are some of the unanswered questions we have. So when Prop 19 was passed, of course, we don't really know the answers to all the questions. So the California Assessors Association, which Carmen's a member of, has given the state at least 20 unanswered questions. And so the state board is going to give us some guidance within their level of authority. But there's some questions they cannot answer, which is going to require future legislation. So some of our legislators going to draft legislation to answer some of these questions. And further, some of those have to be done via constitutional amendment, like another proposition. So we're probably going to see some more propositions here. So some questions my clients have been asking me: what happens if my property converts to other uses? I move into it, and I turn to a rental, or I decide to turn the rental into my home. What do I do? What if there are multiple children? Do we all have to live together? Like Carrie was talking about, should I transfer to an irrevocable trust? There are all kinds of consequences of irrevocable trusts. Or some people are recommending they transfer properties to an LLC. How's that going to affect this? How this is going to change it? So these are some of the many unanswered questions we have, and good luck, Carmen, on dealing with them.
Yeah, and I can actually add a little bit more to that if we can go back to that slide. And so, what happens to the property if you convert it into future use? And so remember, under what is in the ballot language right now, if you transfer the property, you have to basically file basically a homeowner's exclusion, that the fact that you live there, within a year. The law is silent about what happens if you file a year and 1 day. Do you still get the benefit from it, or are you no longer eligible? So there are certain things that are lacking in what the legislation included and would need cleanup language. On top of that, many of us may potentially live in the home, but end up having to move somewhere else. In that situation, what happens then? Is there a time period in which you have to live in the property in order to benefit from this exclusion, or is this an ongoing thing? I think the state legislature will probably take a look at the legislative intent, which likely was that they intend for you to actually utilize the home. And so it is very possible that you might actually see that it's perpetual. You're going to potentially need to always prove that you live there as a primary residence in order to continue seeing this benefit. This is still information that needs to be worked out at the state legislature or the BOE in terms of guidance. So we can't really give you an answer because we haven't heard definitively from them yet. There were questions about multiple children, right? So I want to pass on my home to 2 children or 3 children, but not all 3 of them are going to live there. What if one lives there? Does that qualify for the exemption? We think that it would, but again, we still have yet to see the clarification language from the state, because again, the intent was to keep it as a family home. And so long as it stays in the family, it seems that would be right. But again, we don't know yet because the law hasn't really specified these elements. And so I think that there are many pieces that we'd like to answer for you. We just don't have the clarity from the state law yet about what that looks like.
Also, I'd like to point out a couple of other points too. So the question about the LLC, one thing I need to point out to you is that an LLC has what's called a fee on top of the $800 a year you have to pay for the LLC. And if your income's above a certain amount, you can pay up to $13,000 of fees if you sell the property out of an LLC. So you got to be aware of those extra costs. And one thing we haven't talked about today is debt, mortgages. What if the parents are transferring property with a mortgage? What are the consequences there? Or what if the children want to add a mortgage to their property? So a lot of complicated rules we need to consider. So not just taxes, but also lending issues.
Yeah, and actually I did want to mention one last thing on the LLC issue. So an LLC is one type of legal entity. There are actually many multitudes of types of legal entities that can exist, right? And so many people have asked the question about, can I put this property into a legal entity, basically create a legal entity to hold title to this property and avoid this kind of situation? Well, just know that once you go into legal entity territory, there's also different property tax rules that apply to legal entities and what triggers a change in ownership for reassessment for legal entities. So that's just something to also know, is that, just putting it into a legal entity doesn't mean that it avoids property taxes. It means that there's a different set of rules for what those property taxes are. And then again, in addition to property taxes, as Larry was talking about, there are other kinds of taxes and other kinds of financial considerations that flow alongside with legal entities that are above and beyond property taxes. So here are some additional resources that we want to make sure that you know about. We're going to continue to put information out there so that you have credible access to information as much as possible. But from a beginning point, we want to bring your attention, of course, to the website that we've put together on our own website, sfassessor.org, to understand Prop 19. That exists. The State Board of Equalization also has a website. We also know that the State Bar of San Francisco basically is offering also free consultations for wills and estate planning as well. So just kind of know that these are a few of the resources that might be in existence. On the next slide, what we also wanted to share with you is that our office is open. And so for many people, in order to effectuate sometimes a transfer, you might want to record a document like a deed that essentially changes from you to someone else owning that property. Many people have asked under COVID-19, are you still open? How do we access your office when physically you're not really, you can't just walk in essentially. And so there are a few ways we want to make sure you know about this. But again, please remember, if you're going to do this, don't wait to the last minute, because there are instances where there's going to be some problem that's going to potentially impact your deadline. So the ways that you can record are 3 primary ways. We do have a drop box that is set up in San Francisco at City Hall. So if you go to the Grove Street entrance of City Hall, there's actually a drop box. You can see a rather nondescript picture here that shows it. The reason why we don't really advertise it is because, you know, it is a drop box. It is secure, but we also don't want to necessarily say, hey, here's where people are dropping off vital documents, although we are securing this box. Just know that this is here that you can drop off. We pick up at this box 3 times a day, Monday through Friday. Our last pickup is roughly around 2 p.m. or so, and we typically will record on the same day for anything that is dropped off in this drop box. Number 2, you can mail it to us, U.S. Postal Mail, and send your documents to us. Remember that we probably have a little bit of a lag in terms of seeing the processing of the mail come through to our office. So the most direct way really is the drop box if you're able to do it. Don't forget to make sure you have all of your completed documents signed and so on. And then finally, the last way, which is the easiest if you can find it, is to have an electronic filer. So many title companies, banks, and other institutions or law firms are now what we call certified filers with us. And so they can actually submit these documents electronically, securely to our office as well. So that's all. Those are the 3 primary ways to do it. The other thing I will say is that we typically also require a recording fee in order to get the document through. We have to reject documents if we don't receive payment. So even if we've received your document in a timely manner, but you did not include a check or the right amount, we're unfortunately going to have to return that entire document and not record that for you. So just know that when I say please give time, is that you also want to give time in case there was something that was wrong in what your document was that you submitted. Either it was incomplete, something was incorrectly filled out, you had the wrong recording amount fee that you provided, we're going to have to return that document to you by mail. And that's going to take time for you to realize that it came back to you and then for you to resubmit. So just know to spend time to make sure you do it earlier so that there's no kind of issue with the deadline. The other thing I will just say is that remember that February 15th is a legal holiday. There have been many questions that have said, well, then technically, what will that look like? You know, does that mean that you're actually going to be recording and able to have these transactions come through on February the 16th, or is it really February the 12th, which is Friday before? There is actually a fair amount of questions that is being surfaced to the State Board of Equalization on when the exact cutoff date is. So just know that that's not exactly entirely resolved yet. We haven't had kind of final say yet. So as a result, please just assume you do it earlier rather than later. I went through this earlier, but worth also noting, here are some of the common reasons why we might reject a document and send it back to you without recording it. Either that there is an insufficient recording fee, you forget to put in the block and lot number, basically the APN number, assessor's parcel number in it, or the situs or the kind of the property description. Usually people have forgotten to include or complete a preliminary change in ownership report or a transfer tax affidavit. Legal descriptions are missing. These are common reasons why we may reject the document. So just know there's a fair amount of things you're going to want to pull together. It's pretty technical, and sometimes people just don't know all of the information, and so they send us information that is not complete. So please give yourself the opportunity and time to fix these. You don't want to wait till the last minute and not have the opportunity to fix it and then miss that deadline. Right.
Thank you so much, Assessor Chu. Thank you everyone. Thank you, Larry, and thank you, Carrie, and just everyone. But now we're going to go ahead and open things up for the Q&A portion of the program. Looks like many folks have found the Q&A function, but if you have not, it's at the bottom of the screen. And feel free to type your question into that question box, and we'll make sure that someone from the team grabs your question. But just be cognizant that, as we mentioned, we had over 2,000 attendees register for this event and have received close to 1,000 questions in advance. So we want to start today with one of the most commonly asked themes that we saw with those questions that have come in. And this question is for you, Assessor Chu, and it involves families with more than one child. And this comes from a young lady by the name of Rosa Maria, and she asks, everything I have seen refers to a parent passing on property to one child. I have 2 children, and I want to leave my home to both of them when I pass away. How does the law affect families that want to pass on property to more than one child?
So it's a great question, because this is a pretty common thing, and it's actually the same thing that my parents are thinking about now, because we've got 3 sisters in the household. My parents have 1 home. They're thinking about what should we do in that situation. So ultimately, it comes down to what you want to be doing. Do you want to be passing on this property to two of your children or 1? Here's a few considerations to make. Currently, under the existing law, you can pass on your home, for example, to both of your children. And if they apply for the Prop 58 exclusion, they would be excluded from a reassessment so long as they are legitimately meet the criteria of being your children, all of those different things that we will check box and make sure it is completed and met the criteria for. Under Proposition 19, the same thing would be true. So long as your children are actually able to have it settled up as their primary residence, for example, they would still qualify for this exclusion from reassessment. But remember, it also depends on how much value your property is, right? So if your property is really a very expensive home, let's just say a $2 million home, $20 million home or so, you're only going to see a partial benefit pass on to your children, because there's now a cap on it under Proposition 19. Also, if you're trying to pass on anything but your primary residence, after February 16, you're not going to see that be possible to pass on your property tax savings to them in that way. The other thing to just know is that for many people, let's just say that you pass it on now and your children own it 50-50. So you pass on the property, the home, to your children 50-50. They own it legally as, as joint, as tenants in common, each owning a 50% share. At some point in time, one of your children may say, you know what, I don't want this property anymore. I have my own home. I don't need this property anymore. My sibling, do you want to buy me out of my share? And in that situation, what would happen is that you'd see a transaction that occurs where a sibling is passing on the property to the other sibling. They could do it by gift. They can sell it to them, however they decide to financially make that arrangement. But the issue now is that that is no longer a parent to child or child to parent exclusion. That's a sibling to sibling transaction, and they do not qualify then for this exclusion anymore. So remember, this really just speaks to a parent to child or child to parent or children or multiple parents or multiple children transaction, but it does not include sibling transactions, niece transactions, aunt transactions, uncle transactions, none of that. So just know that this is strictly related to parent to children. I should mention that there was a grandparent to child to grandchild provision as well. That only is possible if the parents predeceases the grandparents. So just know that that exists, but if you have sort of a child who is alive and you also have a grandchild, you can't just say, I'm going to skip my child, passing it on to them, and I just give it to my grandchildren. That only can be benefited or can be used if the child predeceases the grandparents.
Yeah, thank you for that. That's very, very helpful. Very, very helpful. And thank you for that question as well, too. Now, the next question that kind of came through in terms of themes that we saw based off the 1,000 questions that we received is about multi-unit buildings. And Rebecca asks, how does your office handle a 2-unit building if one of the units is my principal residence and I transfer the entire building to my child?
Yeah, so let's just say in that situation, I mean, there's sort of the before and the after, right? So before, under the existing law, you can potentially pass on the entire property because it's got both commercial and residential uses to your child, right? Under the Proposition 19 scenario, the portion that is not the primary residence portion would have to be treated as if you were transferring the property and be reassessed to market value. That's how we believe that we would be treating this. And so again, what would likely happen is that if you've got a 2-unit building, you utilize one of them as your primary residence, you end up passing that property on to your child. Under the Prop 19 scenario, the way that we would look at that is we would say, okay, we see that you're passing it on to your child as their primary residence. They indeed meet the criteria of having it be their primary residence, so they decide that they're going to actually live there. We would treat the one portion the same way as what the exclusion would allow. But for that second unit that is not the primary residence, it would have to be treated as a commercial property or a non-residential property, essentially. And so even if it's under one assessor's parcel number or one APN, for example, we wouldn't be sending you two different tax bills. We would basically do that calculation and then have it be a consolidated bill, essentially.
Can I interject on the income tax consequences of that question? So if the parent is transferring a multi-unit property to their children, you got to review the income tax consequences. So for example, let's say we have a 3-story building. The ground floor is commercial. It's a store. You got a restaurant or something. It's commercial. The middle is a rental apartment. You rent that out to someone. And the third floor, let's say you're living there as your principal residence. So you've got one property with 3 different tax consequences that you got to be aware of. So the depreciation is depreciated differently between commercial versus residential property. And if you're gifting the property to the children while you're still alive, you have what's called a carryover basis, which means if the parents had the properties for a long time, the depreciation might be very low. Versus if they wait till they inherit the property with the step up in basis, you can get a much larger depreciation deduction. So something to think about.
And I should also just mention that when I described how we would typically treat a property like that, that's under our current rules and how we currently do things, right? It's always possible that the State Board of Equalization or even the state legislature are going to say, well, for the implementation of Prop 19, here's how we want you to treat it. So just know that this is how we would normally do it right now. But again, we are still waiting for the state to clarify for some of these items on how Prop 19 would be implemented. So it's not clear if they're going to change that, be more specific about that, et cetera. So just want to make sure that folks know that that is a big piece that is unknown to all of us.
Also, I need to point out one more thing. California tax law is different than the federal tax law. So the depreciation calculation could be different. So a lot to stay on top of.
Absolutely, Larry. No, thank you. So Assessor Chu, I know there's been a lot of questions that have been coming into us, and these two were kind of some of the themes that we've seen. But is there anything in the Q&A that we see that we may want to address this afternoon?
Look through this Q&A and see if there's any kind of ones that we haven't really touched yet.
Okay.
Hold on.
And also feel free, Larry or Carrie, if there's something that maybe you wanted to hit on that you might have missed, please feel free to interject as well.
There's a question in here from Jackson Brown who had some questions about like when the effective date of a transfer would be. So I think that's worthwhile touching base on for just a moment. Just recall that you can transfer property in a number of ways. Sometimes people can transfer a property by recording a deed with our office to say, I used to own it and now it's owned by person number B or person B, basically. In that case, we would typically use the recording date, if that's your instrument of how you're making that change, to be the effective date of that transfer. So when we take a look about whether Prop 19 applies or the previous law applies, we would be taking a look at that recording date potentially. There are other ways that people can transfer property as well. Sometimes you have created effectively a transfer through a different mechanism that is an unrecorded document. And in that situation, we would take a look at when that document was executed, and that would be sort of the guiding post, which we would use that date potentially to determine which law would apply. There is also an instance where maybe someone set up a trust or they set up some kind of a vehicle to pass on their property a long time ago, and they may have passed away, and the death has triggered the change in ownership for their property to pass on to someone else. So we would potentially, in that situation, no document was recorded, right? Nobody kind of filled out a document to say that it's now moving on, but someone passed away. And when that person passed away, it transferred to someone else effectively. We would then take a look at that date of death then to be potentially the date that we would look at to compare which law applies. So just to kind of just know that there are different ways to change property, and we would be taking a look at when the effective date is there.
I do see some questions that Carmen can address here. The questions of the homeowner's exemption. Can you talk about the homeowner's exemption and the consequences? How do you add or remove a homeowner's exemption?
Pretty easy in terms of homeowners exemption. So there's actually a form on our website, and we can put it in the chat as well, where it's a very simple document that you just fill out and you basically sign under penalty of perjury that you do indeed live in that home. That is basically a homeowner's exemption form, but it also is an affidavit basically that's saying, hey, I do live here. This is my primary residence. Now, the thing you should know is that you can only claim primary residence in one place, right? You can't say this is my primary residence, but so is that. And so what the state of California does is that the homeowner's exemption information gets pulled all together at the state level. And when we see that there are people who are claiming multiple places as their primary residence, we have to clean that up. And so essentially they would basically tell assessors in different counties, by the way, you've got this one person who says that this is their primary residence, but they have also claimed this in another place. And so just so you know that there is sort of a statewide clearinghouse for some of this information for us to have it. So we can send it to you, but it's very easy to claim the homeowner's exemption. Right now, it's just a simple document you fill out and you return to our office.
That's great.
There's a question about the transfer of property for seniors, because Proposition 19 also includes being able to preserve your base year value for seniors 55 years and older, for individuals who are disabled, as well as wildfire victims. Just know that we're going to be covering that in depth at another seminar. But because this piece of the law is going into effect first, we wanted to cover the parent to child or the family transfers first. But just know that there will be another webinar that will be coming down that way to talk about that more fully. That does not get implemented until April 1st. And not only that, that is actually an expansion of benefit. It's not a restriction of benefit. So that potentially is more beneficial to taxpayers going forward. Let me see if there's other questions. We've got a question from Kathy Halliburton who asks, does the same rule apply for transferring to nieces or nephews? Recall, this parent-to-child transfer is strictly for parents between parents and children, and then for the other one, grandparents to grandchildren. The State Board of Equalization defines what a child is and also what a parent is and what a grandparent is. And so you're going to want to take a look at those definitions.
We got just a few more minutes, Assessor Chu.
All right, let's see if there's another one that is great. I think the other one that I will, maybe the other thing I will just say, perhaps rather than answering a question, is that many people that I have heard have said, oh, I've set up a trust. And so I've already set up a trust. I don't have to worry about this because once I put it in the trust, this doesn't impact me. And that could not be further from the truth. Remember, what a trust does primarily is that a trust tells basically whoever exists after you what you want to happen to your property, but it also really helps to avoid probate. It helps you to avoid having to go to court to figure out who owns what and who gets what asset. It helps to streamline that. It helps to save that cost for many families. And so when you create a trust, you've set up kind of what your wishes are, but you've also helped to streamline and avoid a costly court process essentially. But the property tax laws associated with this, with Proposition 19, just because you put it into a revocable trust, doesn't mean that you skate by on this law. This will still impact you. So for people who have set up trusts in the past and who are saying, I've already set up a trust, I don't need to worry about this because I'm taken care of, I would really suggest that you go back to your lawyer or whoever it was who helped you set it up to say, what kind of trust did I set up? Because there are different kinds, and will I be impacted by this law? Because again, it depends on if you had a revocable trust, an irrevocable trust, or a whole multitude of different kinds of legal structures that you might have participated in. So just know that just having done a trust doesn't mean that you won't be impacted by Prop 19. Maybe that's the final parting point, is that hopefully people have understood that there are implications from a property tax perspective. There are also other financial implications, and there are many different ways to kind of think about it, including kind of what your existing trusts are and what you should do going forward.
No, that's a phenomenal segue too. I was just going to ask, while we still have a few minutes, I was going to see if Larry and Carrie, if you guys had just any parting bullet points. I think Assessor Chu did a phenomenal job. Just 30 seconds of information that you want our guests to part with.
Well, I think, you know, I think the most important thing is that we have to be very, very careful about what we say. And I think that I do. Just to piggyback on what Carmen said, in terms of bypass trusts that have been set up, a deceased person, a deceased parent passed away, and the surviving spouse has a beneficial interest, but ultimately the property will go down to the children. I think it's unanswered whether or not once the surviving spouse passes, whether that property, because we normally use the deceased parent's exemption, will fall under Prop 58 or fall under Prop 19 if the deceased parent passed before 2/15/2021.
My parting words is don't wait till tax season to deal with this question. Deal with it now before your tax advisor gets too busy and need to understand all the consequences of what you're trying to accomplish.
I will say the final thing I should say that I did see a lot of questions about was that many people have put on their own existing deeds on their title. They've added their son or daughter's name or multiple people's name to the property, right? So they might be owning something in joint tenancy or potentially as tenants in common, whatever the legal way is that you've held title. And just simply because you put them on title, it doesn't mean that it would not cause a reassessment. So for example, let me just walk you through a very simple one. I know we're at the end, but this is, I know, something that would be helpful for folks. You've got two parents and then you've got two children who are now all on title, let's just say as tenants in common, right? In a situation like that, if one of the parents pass away and in your title, you didn't specify that each person owned like 25% or whatever it may be, we assume generally that these four individuals own this property in equal share. So if one of these individuals were to pass away, one of the parents, let's just say, were to pass away, we would assume if there was rights of survivorship in a tenants in common, you don't, so you have to specify who it goes to. We would then have to do the calculation for who it went to, right? So let's just say the parent said, I'm going to give it to my two remaining children. Well, then that potentially would be excluded from reassessment if those children filed a Prop 58 before February 16. After February 16th, the children potentially would have to live there. So there are certain things that you just want to know that simply putting your name on a title of a deed does not prevent you from being impacted by Prop 19 potentially, or any of these reassessment issues. So you're going to want to make sure that you understand those pieces more thoroughly. And I guess I just want to say thank you for joining us, and to DJ and to Larry and to Carrie for spending your time with us and really giving us your advice and just really kind of reflecting what people's worries and anxiety and questions have been, because I think the more people hear, the more they can start to understand, think about what they want to do and get ready for that future. So thank you all very much.
That's a phenomenal segue. Thank you. Our very own City and County of San Francisco Assessor Carmen Chu. If you do not, make sure you follow her on Instagram. I love Cooking with Carmen. One of my most favorite shows to check out on Instagram as she focuses on some of our local chefs and businesses here. Big thank you to Larry Pond, as well as Carrie Reardon Sykes as well too. And thank you all for joining this event. We hope the information brought to you has empowered you to have a conversation with your family to talk about taking the next steps that make the most sense for you all. And at this time, I want to thank all of our speakers again for being here and being amazing and providing their expertise. With the effective date of Prop 19 around the corner, I know it's an incredibly busy time for all of you. And I want to thank you again for taking the time out to volunteer and spend time with us this morning and this afternoon and getting this vital information to the community. And last but not least, I want to thank the Assessor's team. Nicole and Annie have been absolutely phenomenal, along with everyone else. Thank you for putting this together. I know it involves a lot of planning and behind the scenes to put something like this together. And if you want to, and I want to thank them, and if you want to thank them, they would really appreciate it if you can complete the poll. It should pop up now, so we can keep good documentation of our attendees and keep on advocating for more resources. Oh, it just popped up right now, popped up in the middle of my screen. So for more resources to bring back similar types of events and more information so we can get it out to the community, okay? And we will keep everyone who registered up to date about a second webinar in the spring, which will focus on the other half of Proposition 19, the benefits for seniors. I want to say Happy New Year's to you all, and thank you again so much for joining us this afternoon. It's been a pleasure.